Coming up next on Arizona Horizon, a debate on the legality of Bisbee's city ordinance on civil unions. We'll hear both sides of the issue, and also tonight we'll hear from minority leadership at the state legislature. Those stories next on Arizona Horizon.
Arizona Horizon is made possible by contributions from the Friends of 8, members of your Arizona PBS station. Thank you.
Good evening and welcome to Arizona Horizon. I'm Ted Simons. The SkyTrain made its public debut today at Sky Harbor. The passenger train runs 24 hours a day, 7 days a week from the East Economy lot to Terminal 4. Phoenix Mayor Greg Stanton presided over a ribbon-cutting ceremony this morning. The train opened to the public at noon. And a state lawmaker has canceled plans for a bulletproof vest demonstration at the Capitol. Representative Bob Thorpe canceled after legislative staff attorneys advised that it was improper to conduct sales pitches to lawmakers on state property. The Flagstaff Republican today called this idea, quote, a rookie mistake. He says he will simply provide contact information to colleagues interested in the vests, saying that he wants to provide safety options for lawmakers in light of the shooting of former Congresswoman Gabrielle Giffords and a Texas prosecutor. Well, the city of Bisbee passed an ordinance last week that created same-sex civil unions. Attorney General Tom Horne says the ordinance is unconstitutional and may take the city to court. Tonight, we look at both sides of the issue with Attorney General Tom Horne and Tim Nelson, a Phoenix attorney and former Chief Deputy Attorney General. Good to have you both here. Thank you so much for joining.
Great to be with you.
Let's start with why would you want to go to court over this ordinance?
Well, I will go to court. Not just might, but I will go to court. And the reason is because it violates state statutes. And I want to make it clear, I've made it clear in every single interview I've ever done, I have nothing against civil unions. I point out the Phoenix City Civil Union is perfectly acceptable. It's a registry for people to visit each other in hospitals. It doesn't violate any state laws. But the Bisbee statute has 7 separate paragraphs, each paragraph with a statute that they say will be enforced differently in Bisbee than it will be enforced elsewhere around the state. And a city doesn't have the power to do that. And those of us who are in elected office, and Tim was the Chief Deputy at the Attorney General's office, know that there are limitations to our powers, and we have to understand those limitations. It would be really bad if I, as Attorney General, exceeded my powers. I could make life bad for some people. The same thing is true of city council people. They can't exceed their powers, and they don't have the power to change state statutes. Only the legislature has the power to do that. And I will defend to the death their right to go to the legislature and urge that they adopt civil unions. But the city does not have the ability. It can adopt civil unions that don't violate state law, but they don't have the ability to violate state statutes. That's beyond their powers.
Okay, so how is this constitutional?
Well, because the city of Bisbee has taken enormous steps to make sure that they don't exceed their powers. They talk specifically about the current Arizona law that defines marriage, and they make clear that what they're talking about here are civil unions. And keep in mind, Ted, that the voters in Arizona have voted on this issue twice. In 2006, they voted on a broader ban on gay marriage that would have also specifically prohibited civil unions. The voters rejected that. 2 years later, when they passed a law that said marriage is between a man and a woman, but it didn't address the issue of civil unions, and it specifically left open the opportunity for cities like Bisbee to pass the ordinance that they did.
So if that opportunity was there, what's wrong with Bisbee taking that opportunity?
No, I agree with that. They can have civil unions. They just can't have it in the way they've written it. As I mentioned, Phoenix adopted a civil union statute that I totally have no problem with because it doesn't violate state statutes. But what they can't do is violate a specific state statute. We're dealing with community property, inheritance of property, appointment of personal representatives, and so on. These are things where there are state statutes that are matters of statewide concern. The legislature has passed a statute. By definition, a state statute applies throughout the state. And Bisbee wants to say, well, within Bisbee, the state statute will be different. You can't do that. That's beyond their powers.
Can a city do that? Is it beyond their powers?
It is not beyond their powers. What they've said is that to the extent that the law permits, they want to afford equality to civil unions. And they recognize that there are limitations on what they can do in that regard imposed by the state law, but they want to go to the maximum extent possible to afford equality to civil unions, and they're allowed to do that within the confines of their city.
Why can't they do that within the confines of their city? I know you mentioned that this could somehow affect other areas of Arizona. It sounds like it's not going to impact areas outside of
Well,
Bisbee.
they can't change state statutes within the city. A city has no sovereignty. A state has sovereignty and the federal government has sovereignty. Cities are creations of the state, and they only have such powers as were given them by the Arizona Constitution and by Arizona statutes. So they can deal with matters of purely local concern, parking, speed tickets, zoning, public works. Those are within the powers of the City Council. They do not have the power to change a state statute. If a matter is not of local concern but of statewide concern, the legislature passes a statute that applies throughout the state, and no city can opt out and say the state statute will be different. Tim and I both have the statute in front of us. It says that the parties to the civil union will have the same benefits pursuant to Title 25 as married people, including the following, and then it mentions community property, inheritance, and so on. So what they're saying is that the statute that gives certain benefits, such as community property, only to married couples, will now be, as a matter of law, within the city, given to people in a civil union. They don't have the power to do that.
They do have the power to control how they function as a city government, what benefits they confer to their own city employees, for example. They can choose to provide benefits to civil union partners who are employed by city government. And again, this ordinance says on its face it applies only within the city limits, and it applies only with respect to laws that do not conflict with the Constitution. The Attorney General talks about you can't rewrite the state law. This doesn't do that. It doesn't do it. It makes no reference to any state laws other than to point to the fact that they're going to interpret their ordinance in harmony with state law to the extent possible.
So community property rights only within city boundaries, guardianship, adoption, these sorts of things only within city. What happens when you leave Bisbee?
Well, I mean, there are issues. Anytime you write a statute or an ordinance, there are going to be ambiguities that will have to be decided on a case-by-case basis. What I object to is the Attorney General's effort to try to bring a facial challenge before we've even seen how this would apply to particular people within the city of Bisbee. Once Bisbee has had an opportunity to operate under the ordinance, if there are cases where someone believes there's a conflict between the ordinance and state law, we can adjudicate that separately. But this ordinance should be allowed to go into effect and should be allowed to operate until such time as there is an actual conflict.
The argument that you're a little too eager on this one, I think,
Right.
was what we're getting at there as well.
Let me explain
Please.
why. But first, let me just mention, I have absolutely no problem with them giving benefits to members of civil unions. That's within their power. What's not within their power is to change the statutes that I mentioned. And let me tell you why it's important that we do it right off the bat. Let's assume that you have two people who are in a civil union, and they think because of this ordinance they have community property, and that if one of them dies, the other will get that property or will inherit or can be an executor and so on. When it comes to court, they won't get that because the city doesn't have the power to change the statute. They need to know that they won't get that so that because they can make contractual arrangements. They can write wills, they can write contracts, they can deal with that if they know that they need those. But if they think that the city has changed the statute so they'll automatically get the community property or the inheritance, they're being deceived by the city because the city does not have the power to change the community property law or the inheritance.
That is one of the criticisms here, is that this just confuses the issue, that it makes less clear what people can't do, and can and cannot expect.
Well, keep in mind that our courts require that you actually have a case or controversy and that you have standing. In other words, you have to have actually suffered an injury. So if there's a person who lives in Bisbee who wants to get a judicial declaration related to the scope of the ordinance, that's something that they're free to do. But to try to strike the ordinance down in its entirety before it even takes effect is not constitutionally proper.
As the Attorney General, it's my job to enforce the law. I need to be sure that public officials don't exceed their powers. And so it becomes my responsibility. And this was analyzed before I made the decision by lawyers in our office saying, this is unconstitutional, it's contrary to statutes, you have got to put a stop to it. And first thing we did was write a letter to tell them, but they said if they don't accept your ideas, you've got to go to court, because people will think that they have these rights that they don't have. And so you have to stop these people from being deceived. If the city is saying it has a civil union that grants community property rights or inheritance rights that it has no power to grant, people are not going to take other actions that they could have taken to protect themselves.
Are there other city ordinances out there that also are going too far in terms of their authority? And if so, are you looking to take them to court?
There are none that I know of. There was the The city of Phoenix, as I mentioned, passed a civil union statute that I think is perfectly fine because all it does is establish a registry for visitation. That doesn't violate any state laws.
What about other ordinances, though? It have nothing to do with civil unions, but just are simply city ordinances that some would say go too far.
Well, it would have to be brought to my attention. If they violate state statute, I might need to take action. But this is the only one that I'm aware of.
The idea that, again, is it fair to Bisbee couples for them to think that this is applicable and when it really doesn't exist out of town? I'm getting back to that confusion thing because that is a factor, isn't it?
What's not fair to Bisbee couples is that some of them are being denied benefits that other couples are entitled to under state law. And we have equality under law throughout our U.S. and state constitutions, and that's an important concept that is really what the Bisbee Council is trying to address here. They're trying to say, to the maximum extent possible under Arizona law, we want to guarantee equality for civil union couples that is equivalent to the rights that are they made available to married couples. And that's what they're really after. And so the fundamental fairness is addressing the fact that the status quo is one that is very unfair to civil union couples.
Well, if you want to make that argument to the legislature, you have a perfect right to do it, and I have no problem with that. But the legislature is the place to make the argument. You can't make the argument to a city council to change a state statute. That's beyond their powers. They don't have the power to do that.
With all due respect, Mr. Attorney General, I think that our legal history is complete with people having to go to court to enforce equality under law. That's been true in the civil rights movement. That's been true with regard to gender equality, and it's certainly true in this case.
Is this something that you see Bisbee perhaps trying as a test case?
Perhaps so, yes. I think that's exactly right.
Well, there is actually a case before the U.S. Supreme Court dealing with this issue right now, and the Supreme Court may decide the Constitution requires gay marriage. That's within their powers. But the City Council doesn't have the power to change a state statute. That's what I'm dealing with. The City Council has certain limited delegated powers. They can deal with parking and speeding tickets. They cannot deal with state statutes dealing with community property and inheritance. That simply is the law.
Last question. We kind of referred to this earlier regarding perhaps an eagerness on your part that is politically driven on this particular point, this particular issue. Is this worth your office's time and effort to go after something like this?
Well, the politics went the other way, actually. When it first came up, I said, I don't want to deal with this. 90% of people support civil unions. The politics aren't good. But I got a memo from the lawyers dealing with the issue. They did the research, and they said, this is contrary to Arizona Constitution statutes. You have to send the city a letter, and if they don't accept the letter, then you're going to need to bring an action in court. Now, what am I supposed to do at that point? Am I going to say, well, I'm going to ignore what the lawyers say because politically 90% of people support civil unions? No, I have to do. I'm the Attorney General. I'm the Chief Law Enforcement Officer. I have to do what's right with respect to the law.
Last question for you. Would the Attorney General be derelict in his duties not to pursue something like this?
Oh, no, I don't think that's the case at all. I think the Attorney General has to look at the ordinance. They need to look at the state statute, but they also need to look at the Constitution and the Equal Protection Clause of the Constitution. And I think what we have a situation here is an effort by Bisbee to address an inequality that exists in Bisbee and in other places in Arizona as well, and to do as much as possible within the confines of state law, and again, without changing any state statute, to address that inequality. And the Attorney General should support that.
The U.S. Supreme Court is dealing with the constitutional issues. The City Council of the City of Bisbee does not have the power to make those kind of constitutional judgments. They have only those delegated powers to deal with local issues. They are changing state statutes on community property, inheritance, and the other 7 subjects, and they don't have the power to do that. That's the issue.
We need to stop it right there. Gentlemen, good discussion. Good to have you both here. Thanks for joining us.
Thank you, Ted.
Thank you.
Get the inside scoop on what's happening at Arizona PBS. Become an 8 Insider. You'll receive weekly updates on the most anticipated upcoming programs and events. Get the 8 Insider delivered to your email inbox. Visit azpbs.org to sign up today.
Democratic lawmakers are still in the minority at the state capitol, but their increased numbers may prove key in helping Governor Brewer pass Medicaid expansion. Joining us now is Senate Minority Leader Leah Landrum Taylor and House Minority Leader Chad Campbell. Good to have you both here. Let's talk about this idea that are Democrats entirely on board, gung-ho, with the governor's plan?
One of the things that's really important to understand about the Medicaid is the fact that as Democrats, of course, we want to make sure that we have something in place and soon and very soon. It's a time frame we have to be cognizant of. But at the same time, you know, depending on how this is tied into the budget, we certainly would not want to have something where it would hurt populations, where there's various poison pills in the budget bill. So one way to prevent that is to be able to work together on a budget. I've seen it happen before. It'd be nice to have that occur. But certainly we would not want anything that would jeopardize and be harmful to communities.
So where is that measure? Where does that metric begin and end?
Well, that's a good question, and I'm not sure if we have the answer right now. I think, unfortunately, and I think Leah would agree with me, we would have hoped to have seen the Medicaid issue be a standalone issue, been voted on already, move forward on this. It was such an important issue, both for the economy of Arizona as well as the 400,000 people that would get health care, that it should not have been used as a political football. And unfortunately, I think it's been caught up in some other issues going on down there. So we need to put aside the politics on this one, get the job done, work in a nonpartisan way, and just get this thing done so we can move on to the budget and other key issues.
But is there a chance of Democrats splintering off if things get too far afield?
Well, I think as Leah said, if you put too many poison pills into something, then we need to reevaluate. We're not going to vote for Medicaid simply to vote for Medicaid if at the same time it's going to hurt another population out there, or it's going to have a massive corporate tax cut package attached to it, something like that. I don't like to deal in hypotheticals, but we're going to look at the final package and do what we think is best for our constituents and for the state.
And time is ticking for the legislative session. The reality, the vast reality is we have not yet even started having true budget conversations, and we're getting late in the game. So we really need to start moving in that direction. Again, would have been great if it was standalone. Not quite sure what could happen with that. Could always be a special session, anything called, just to deal with the Medicaid issue.
Real quickly, last point on this. I heard something that President Biggs was going to allow a vote, was always going to allow a vote, might allow a vote. What are you hearing on that?
You know, there's a couple of different things going around. Quite frankly, if it's going forward as a vote, I'm not quite sure if it's going to be tied in with the at this point, it looks like it's tied in with the budget. So then if that's the case, you'd have to have the whole budget negotiation going forward. Or maybe it's something we don't know what's going on. If it is something that's going to be standalone, there's lots of conversation about having it tied into a Prop 108. That can be very difficult. Moving something like this forward, certainly it needs to just stand alone. There are individuals that truly need this Medicaid expansion to go forward.
All right, let's shift gears here. HB 2147 puts the burden of proof on the unemployed for benefits. What's wrong with that idea?
Horrible idea for multiple reasons. Oftentimes, a person who's lost their job is not going to be able to get that proof for different factors. I mean, one example would be a small business that goes out of business. They let go of their employees. How is that employee supposed to be able to track down that former employer and get the proof? We should not be putting the burden of proof on the people who need the help. There is no problem with our current system. We've heard that time and time again. It works just fine. If anything, the abuses are on the corporate side of it, not on the side of it for the people that are looking for help while they're trying to find a new job.
And yet we are hearing that businesses could get hit with higher unemployment insurance premiums, and they have to jump through hoops and hurdles when folks abandon jobs, and it's difficult for them to prove these people are unemployed.
You know, there is a process that is in place right now, and if there is an employer and they lay off or let go of an employee, there is a true process where you can go through an appeals process, the whole 9 yards, plus there's paperwork that is sent in. So as an employer, you can be able to fill that paperwork out and say if you agree or not that this employee can get the unemployment insurance. The point of the 2147 was to try to move towards preventing this fraud. Well, if that's the case, then there are other mechanisms that can be set up. There's been a long trail of unemployment bills that are out here really truly to hurt those that have paid into the unemployment benefit, whether it's drug testing, having to have this random drug testing, and now we're moving over here to have the burden of proof on the employee. But there's not a requirement for the employer to give anyone a letter or proof. Yeah.
So when folks who support this say that there's just too many hoops, too many hurdles for businesses to jump through when people abandon jobs and these sorts of things, and there is fraud out there, you say?
I say it's not true. Again, there may be some things we have to correct, minor things, some minor tweaks to the system to help out businesses. But the bottom line is overall the system works very efficiently, and we should not be putting that burden of proof on the former employee, the person who's trying to get back on their feet, trying to make sure that they're finding a new job. They need the help that we should offer them. They need the help to get back on their feet. But again, overall, the system has worked just fine. There's a few cases here and there. We may need to make some minor tweaks, but this is an overhaul that was just unwarranted.
The exemptions for teachers and church child care workers, these sorts of folks, make any difference to you?
No, again, I mean, I think that actually shows some of the problems. Why are you exempting one group of people? If a law needs to exempt certain groups of people, that probably means it's not constructed properly, I'll be honest with you.
Guns in small and or remote schools. This was an interesting situation. It got to be like 30 minutes or 20 miles away from the nearest law enforcement. First of all, your thoughts, and secondly, the idea of adding, was this the one that amendments were attempted to add to this bill?
Absolutely.
And what was that all about?
We had amendments that we wanted to add on this piece of legislation to further promote safety, to be able to make sure that, say for instance, if there was a gun misplaced on a campus, then there would be notification sent out to parents. As a parent myself, I have children that are in school. I would want to know if there was a gun that was misplaced on their campus, not to mention the fact that it's the board that's given this authorization to an employee, any employee, whether it's a cafeteria worker, whoever it is, to say that they could carry these concealed weapons. And truly, that sounds like a lot of legality that can fall in, liability that can come, because what gives that board the authority or the knowledge to be able to go forward and say who can carry these weapons? In the military, as well as at the police department, there's academies you have to go through. There's boot camps in the military, training. Now we're saying, as it relates to anyone, a registrar, cafeteria worker, go for it. We'll go ahead and say that you're deemed as responsible.
There are so many problems with this bill. And you know, I was on this show a few months ago with Rich Crandall, who's the sponsor, and we debated our different proposals because I had my own. That was very different than his, obviously. But the one question that I can't get an answer to, and I asked Tom Horn this a couple months back on a town hall panel we sat on, is what happens the first time a teacher accidentally shoots a kid or another teacher or a parent? And nobody's giving me an answer to that because there is no answer for that question. The liability issues alone make this unreasonable. And when we debated this bill in appropriations 2 weeks ago, we had the AZ Post come in and talk about the training requirements, and they require 40 hours of training for this. That's not enough training, and everybody knows that. You're talking about putting somebody in a very complex environment with a lack of training, and you're making things more dangerous, not safer.
And this happened in Texas, actually, where an individual, they tried this, and a teacher accidentally shot themselves throughout the training.
I think the other side, though, would say that basically this is a safety net for a worst-case scenario in small town, in remote schools. Why not for that kind of scenario?
You know, there's a couple of things. First of all, when we were debating this bill, there can also be the temptation for expansion. You go from rural and then what next? Now you're going to go into urban. But secondly, there are law enforcement entities that have a jurisdiction that are by the schools. So whether it's dealing with...
But if it's 30 minutes or 20 miles away, what do you do?
We put school resource officers back into schools. That's what my plan would have done. We allowed the schools to make their own choices. We funded it. And quite honestly, not just with this issue, but with many issues facing this state, I'm tired of hearing from my colleagues on their side that this is the best we can do, or it's a stopgap measure, because that's not a real solution. We have the ability to do this. We have the resources. We can do it. My plan proved we could do it. We have to step up to the plate and make sure our schools are safe and our kids are safe. And if we don't do that, if we can't do that, then we're failing everybody in the state.
And none of those bills were heard, by the way.
No, none of them.
We had bills for school resource officers to make sure that we could also look at strategic plans of how schools can better protect from how they look aesthetically, making sure that you're setting things up. None of these were heard, and nor did we sit down at a table all together and really come up with something that could protect
And
our
we got about
children.
30 seconds left. I wanted to ask about that because all of those amendments, I mean, nothing really much came of it. And I understand that these were unheard bills and presented as amendments, but was this a wise tactic, do you think?
You know, anytime you're talking about having a possibility of putting a child or a teacher or any individual that's at a school or wherever there's children in harm and danger, I never look at that as being wise. We talked about school resource officers. To me, that's a wise choice.
Okay, we have to stop it right there. Good to have you both
Thank
here.
you.
Thank you for
Very
joining
welcome.
us. And a reminder, Senate President Andy Biggs and House Speaker Andy Tobin will join us in studio this Thursday for their monthly visit to Arizona Horizon. Tomorrow on Arizona Horizon, April 15th, just around the corner, we'll give you the latest state and federal tax tips, along with information about the most common tax frauds to avoid. That's Tuesday, 5:30 and 10 on Arizona Horizon. That is it for now. I'm Ted Simons. Thank you so much for joining us. You have a great evening.
Arizona Horizon is made possible by contributions from the Friends of Eight, members of your Arizona PBS station. Thank you.